Assalamualaikum warahmatullahi wabarakatuh. So we will presenting our term paper on the topic chosen, legal maxim and their significance in Islamic banking and finance. So this will be presented by me, Sharifah Iziana Atifah, and my teammates Nurul Anis and Nurul Amani. So I will begin with introduction. Jurist has defined a legal maxim as a general rule which applies to all its particular, and basically this legal is created to provide better understanding of the Sharia, in the sense it is parallel with fiqh and play an important role in resolving the conflict, especially related to new circumstances among the society. And there are a lot of legal maxims that widely apply in Islamic finance and banking as to develop a conceptual framework in Islamic finance. So our objective for this theme paper is to look into the understanding of legal maxim and the application of Islamic legal maxim in the Islamic finance and banking framework. The sources of legal maxim, they are consist of three: Al-Quran, Hadith or Sunnah, and Ijtihad. So the most of the legal maxim wording taken from the Quran and Hadith. These two are the primary sources that can influence the Islamic jurists to formulating the legal maxim. The example of legal maxim is hardship is to be elevated. There are also maxim formulated by jurists called Ijtihad, derived through extraction of general rules based on the primary sources, Al-Quran and Sunnah, from the Arabic language, and also based on logical inferences. For example, certainty cannot be removed by law.
So next on the classifications of legal maxims. So generally legal maxims can be classified into several different categories based on their scope of application or even acceptance among scholars from different fiqh schools. So in terms of scope of application, they can be categorized into the major maxims or even the other maxims. So major maxims basically refer to the 5 leading maxims which cover most if not all subjects of fiqh, and these matters are determined according to intentions. Hardship begets facility, harm must be eliminated, certainty cannot be removed by doubt, and custom is an arbiter. So secondly are other maxims, and these are maxims in terms of applicability are lesser in degree to major maxims. These are basically all of the maxims other than the 5 major maxims and are typically corollaries or commentaries of the 5 major maxims, but may also be extensions of some other maxims. An example would be the legal maxim, a greater harm is eliminated by tolerating a lesser one, and this is basically a corollary of the major maxim, harm must be eliminated. So next is on their acceptance among scholars from different fiqh schools. Firstly, there are maxims which are accepted pretty much unanimously by all scholars from different fiqh schools, and these are generally the 5 major maxims and general maxims which are applicable to a wide variety of fiqh subjects. And secondly, there are also maxims which are disputed among the different scholars from different schools of fiqh or madhabs, and this may also be referred to as al-qawaid al-madhabiyah. An example would be the legal maxim, in contracts, effect is given to intention and meaning and not words and forms, and this particular maxim is widely applied by the Malikis and the Hanafis but only applied by a minority of the Shafi'is. So moving on, we'll be discussing 3 legal maxims which are pertinent to Islamic finance. The first one being the presumption of validity and permissibility applies to all contracts and conditions. So this legal maxim is an extension of the legal maxim. Permissibility is the original rule for all things, which has been argued to be a commentary of the legal maxim or the major maxim, certainty cannot be removed by doubt. So it basically bears the meaning that all contracts and conditions are generally permissible as long as they have not been prohibited in the Sharia. In this sense, it's important that the nullification of said contracts should be basically justified or even proven by evidence in the textual source. And an important note here is that the extent of permissibility is generally wide, whereas prohibitions are relatively few. So this legal maxim is grounded on some textual evidence based on the Quran and Sunnah. For instance, in Surah Al-Baqarah, it is stated that He is the one who created everything in the earth for you, and in another verse in Surah Al-An'am, it is said that He has detailed for you what He has prepared for you. And what this entails is that basically human beings are are allowed to utilize the resources of the earth for their advantage as long as they do not transgress the Sharia. And in a hadith, it was also narrated that the Prophet had said, what is lawful is that which Allah has permitted in His book, and what is unlawful is that which Allah has forbidden in His book. What He remains silent about is what is pardoned. And the latter part basically conveys that human beings are allowed to partake in all those activities which have not been addressed in the Sharia, given that they are not prohibited. So the first application of the legal maxim in Islamic banking and finance is the stipulation of different monthly premiums for different individuals in family takaful. So this is done based on their risk profiles, which are determined by actuarial data. For instance, the mortality rate or the probability of death up to a certain age, or the morbidity rate, which is basically probability of injuries based on past injuries, are statistically or mathematically developed by actuaries, and these are used to basically determine the pricing of the takaful premium. And the pricing of the takaful premium may also depend on other loadings, such as the health condition of the member of the takaful fund. For instance, those who are healthy are generally regarded to pose only standard risks to the risk pool, whereas the elderly or those working in dangerous occupations pose higher or substandard risks, which warrant the higher monthly premiums. So the idea here is that those with higher risks are charged higher monthly premiums. Secondly is on the combination of contracts. Generally, the issue here is that the prophetic tradition, which has prohibited the execution of two transactions in one, but majority of scholars such as Ibn Qayyim has argued that generally all contracts concluded by individuals are valid, permissible, and enforceable, where the nullification of said contracts or their conditions must be proven by an explicit textual source. But however, there are certain Sharia parameters which need to be observed to ensure the permissibility of the combination of contract as laid down by the IOF. For instance, each contract in the combination must be permissible in the Sharia. Secondly, they must not be made conditional upon one another. Thirdly, the particular combination of contract must not be something that has been explicitly forbidden in the Sharia, such as the combination of a sale and a loan contract. Fourthly, the combination of contract must not be a legal trick to circumvent the prohibition of riba, such as the sale and buyback arrangement of the contract by al-inah. And lastly, it's important that in the combination of contract, there are no contradictory rules or goals of the different contracts. For instance, it would be contradictory to simultaneously gift and lease a property to a person. Alright, so for an example of the combination of contracts which is prominent in Islamic banking and finance in current day, particularly in home financing, is musyarakah mutanakisah or diminishing partnership, where the customer and the bank jointly purchases a property or a house, and then the customer over a stipulated period or tenure will lease the house from the bank, pay rental payments, and also gradually buy back the shares of the bank at the end of the tenure. The customer would have acquired full equity of the property, and the legal title will be transferred to the customer. And this particular arrangement, or the musyarakah mutanakisah contracts, comprises several different contracts, which are musyarakah, the partnership, ijarah or lease, where the customer leases from the bank, and buy or sale of the property at the end of the tenure. And all these three contracts have been deemed permissible in textual sources of the Sharia, which also warrant the permissibility of the musyarakah mutanakisah arrangement.
So let's continue with the next legal maxim, which is the fundamental requirement in every contract is justice. Islam also scrutinizes other maxims beside the five major ones, which is the requirement must be justice in every contract, or in Arabic words, al-aslu fi jami' al-uqud al-adlu. So this maxim generally clarifies that all activities and conditions implemented in the finance or business must be equitable to all parties involved. Before that, we have to know what is justice in Islam. In Arabic, justice is al-adalah or al-adlu, which refers to classifying one thing as equal to another. Al-adalah also can be described as having righteous or veracious goods and services. In essence, the word justice in Islam means to put something where it should be. Thus, it can be seen that justice carries a broad meaning. Furthermore, there are three of the most prominent aspects of justice. First, putting someone in a job or post that fit his skills. Second, to fit our sentence or make the right decision for the situation or the person who will get it. And the last one, to give wealth or property to people who deserve it. Generally, Islam expects an all-encompassing kind of justice that does not care about differences in color, skin or religion, because this foundation is in command of Allah subhanahu wa ta'ala. Allah has asserted in Surah Al-Hajj, verse 85, "We have not created the heavens and the earth and everything in between except for a purpose." This verse clearly shows that the real purpose of the creation of the earth, the heavens, and the whole universe is to uphold the justice and eliminate the devil. Next, application in Islamic banking and finance. So in Islamic banking and finance, the Sharia objective is to ensure that the contracting parties are treated fairly in any financial, business or social contract that they enter into with one another. Injustice should be absent from Islamic financial institution as it is identical to the traditional one. Profit and loss sharing (PLS) contract are an excellent example to see how this maxim is put into practice in IBF. The PLS contract consists of mudarabah and musyarakah. In essence, Islamic banking is based on two fundamental principles. First, sharing profit and losses among participants, and the second one is prohibiting lenders and investors from collecting and paying interest on loan and investment. In this video, I will talk about mudarabah contract. This is an example of mudarabah in Islamic finance. Generally, mudarabah is a contract between a capital provider, or known as a Rabbul Mal, and entrepreneur, mudarrib, under which the Rabbul Mal provide the capital to be managed by the mudarrib, and any profit generated from the capital is shared between the Rabbul Mal and mudarrib according to a mutually agreed profit sharing ratio, or known as PSR. Whilst the financial losses are borne by the Rabbul Mal, provided that such losses are not due to the mudarrib's misconduct, ta'addi, negligence, taqsir or breach of the specified terms of the contract, mukhalafah asyurut. Mudarabah in Islamic finance, the investor will be Rabbul Mal and the bank will be mudarrib. Basically, investor will invest their money in the bank and the bank will manage that money. So the capital may be in the form of cash or in kind, including intangible asset. Where the capital is in kind, it shall be valued in monetary terms, either by agreement between contracting parties or by a third party. In essence, mudarabah is a contract based on fiduciary relationship, or known as Aqdul al-Amanah. Under this principle, mudarrib manage the mudarabah asset in trust and is not liable for the impairment of the asset. Last but not least, there are some criticism of the mudarabah contract. The mudarabah contract seems unfair because only the capital provider has to bear all the losses. From Sharia perspective, Islam encourages sharing profit and losses between contracted parties equally or based on their mutual consensus. So the second issue is the mudarabah contract involve asymmetric information and moral hazard problem. This problem become unfair for Rabbul Mal because most mudarrib will have more information about the project than Rabbul Mal. Next, moral hazard occurs when mudarrib fail to report the outcome of the project accurately due to dishonesty behavior. As a result, this problem caused the contract to be vague and unfair. Moreover, the injustice of the mudarabah contract here emerged when the capital provider, Rabbul Mal, is indirectly guaranteed a fixed return. So basically, a guaranteed fixed return gives additional benefit to Rabbul Mal and it exacerbates the mudarrib. Lastly, the mudarabah become unfair when the mudarrib asks for a guarantee of profit and capital. So the mudarrib should not ask for a guarantee because it goes against the principle of fairness that mudarabah deal is based on. Only Rabbul Mal can ask for a guarantee. Rabbul Mal may take a collateral from the mudarrib to mitigate risk. So basically, the guarantee requirement in mudarabah financing are intended to bolster the cooperation and increase both parties' trust. Although mudarabah seems unfair in sharing the losses, but this contract is permissible in Islam. Many Islamic economists encourage the use of mudarabah contract. Then, the mudarabah contract is also unanimously accepted by fuqaha because it is derived from Rasulullah's traditional practice.
The third legal maxim related to Islamic banking contract is the general principle conferring validity of contract is the consent of both parties, and the effective term and condition are what they agree. For the specification, a contract will be valid if it is agreed by both parties on the term and condition that's set between them. Conversely, the contract will be invalid if there are no mutual consent. The contract also invalid if the stipulated condition contradict with the nature of Sharia and Nas, because the stipulation condition of the contract is not absolutely free to be set. in fact, it is still limited and restricted by certain rules set by the lawgiver. Any of the party involved is not allowed to disregard this contract. The evidence of this legal maxim come from the Quran first. The Quran states, "O you who believe, do not consume one another wealth unjustly, but only business by mutual consent. And do not kill yourself or one another. Indeed, Allah is to you ever merciful." This comes from the Surah An-Nisa, verse 29. And also, there are also from Hadith, Dawud bin Salih from his father who said he heard from Abu Sa'id al-Khudri. Prophet said, transaction may only be done by mutual consent. This comes from Sunnah Ibn Majah. So basically, Islam emphasizes the importance of mutual consent when conducting social interaction, transaction and muamalah between individuals. So musyarakah and mudarabah contract can be related to this legal maxim as the application in Islamic finance and banking. So basically, musyarakah and mudarabah conduct the contract which need to be mutually agreed in the form of profit and loss sharing. So for the overview, those contract mutual agreement from the counterparties to prevent the information asymmetry because they are based on the condition that they agreed upon, and also the risk and conflict between the party involved. The issue arises when equity-based financing is uncommonly used by Islamic bank compared to debt-based financing. Basically, equity-based is for investment through real economic activities from two or more parties entering into the contract with the contribution of the capital that fund from the bank and management of the partnership that come from any entrepreneur. So this issue is because of the factor of insufficient knowledge between the parties that can give several effect to it. When the information regarding the contract is known in details by one party while the another party know only half of what it should be, so unconsciously it will lead to conflict between the two parties. In the mudarabah, the profit sharing, there are high risks as the entrepreneur mudarib, and they knowledgeable about the proposed project and its profitability than the bank itself. It will lead to imperfect information between the contracting parties that against this legal maxim. Since entrepreneur or mudarib manage all the capital fund by the bank, they will likely to violate the agreed term or even use trick to cover their real performance. The slide earlier talked about the issue that against the legal maxim. In this slide, we focus on what to do to reach this legal maxim. The first one is the equity-based financing is permissible, but the action from the counterparties that need to be improved and well managed. For the first to reach this legal is maybe undergoing an effective screening process before selecting the appropriate entrepreneur. So we will get the trustworthy and knowledgeable entrepreneur that we believe to rely on. Then the second is monitor the entrepreneur action, maybe frequent check on the management and performance of the entrepreneur, and then have extensive knowledge about the contract and understand the term of the contract. And the last one is the strategy made by Bank Negara Malaysia as investment income platform (IAP). This platform lessen the bank's involvement, whereby this platform will be directly link the fund provider with the business partner. So they basically can choose their business partner that they believe in.
So to conclude, we can see how legal maxims are widely applicable in the field of Islamic finance, especially with the emerging legal issues of the different forms and complexities of contracts and transactions in today's society. It is imperative that the legal maxims are used as a tool to pass on legal judgment on their permissibility. And a key takeaway here is that the use of legal maxims can actually promote leniency and also encourage or inculcate product innovations in Islamic banking and finance, which would be appropriate to the current financial needs of society, while also maintaining conformity to the Sharia or the sanctions of the Quran and Sunnah. I think that is all from us. Thank you. Assalamualaikum warahmatullahi wabarakatuh.